Hello everyone. Thank you to be here with us today. Thank you for those spending their lunch hours with us, and for those that is earlier in the day. Good morning. My name is Arianne Bouchard. I'm a partner in the Labor and Employment Group here in Montreal at Benton's office, and I'm with my colleagues, a senior associate in our group, Sarah-Émilie Dubois. We will be your presenters today. We also have a colleague that is connected online, Stephanie McDonald, who is monitoring the Q&A. Stephanie is reading your questions, and we'll be able to answer to that at the end. Without further ado, I'm going to introduce you to the presentation plan of the presentation of today. We're going to do a short introduction, talk about the context and the objectives of the Act. And it gives me the opportunity, I realize I even didn't mention the name of the Act, but basically the webinar today is on the Act to prevent and fight psychological harassment and sexual violence in the workplace. I guess everybody knows that at that point, but that's useful clarification to make. Then the core of our presentation is going to be to discuss the main amendments introduced by the Act. As you're going to be able to see through the presentation, it's not like the Act will not exist in itself, like it's just an act to modify a statute to modify other statutes. We'll go through the main one. Then we're going to discuss a few key considerations for employer. And finally, we're going to have a short conclusion, and if time's allow, we will try, but we just don't know how many questions we're going to be able to take, but we're going to take as many as possible. Next slide, please. As we were mentioning, the presentation today is on the Act to prevent and fight psychological harassment and sexual violence in the workplace. It has just been adopted a few months ago. We wanted to take the time to really dig into it, look at all through the change, and today our presentation is going to be quite exhaustive. That being said, we're not discussing all changes. There are a few ones that we choose to left out. So if you have more questions, feel free to reach out to any of us after the presentation. Next slide, please. As a matter of introduction, basically the context and objective of that Act is to prevent and fight psychological harassment and sexual violence in the workplace. The way that the legislator decided to do it, to achieve that purpose, as I was mentioning, is by amending several laws. Today, the acts that we're going to discuss that were modified by the acts are the Act respecting occupational health and safety, the Act respecting labor standards, the Act respecting industrial accident and occupational disease. We're not going to cover it in the presentation, but it also modified the labor code as well as a statute governing the students working in the workplace, but we're not going to discuss about that today for clarity. We see that one of the purpose that the legislator had in introducing the modification that are done through the Act was to bring a greater consistency in occupational health and safety legislation versus labor standards legislation. One thing that is interesting is that in all other provinces of Canada, we realize that the topic of psychological harassment and workplace violence had been addressed through health and safety legislation, mainly in Quebec, back in 2002 and 2003, when they were discussing the first iteration of the inclusion of topic of psychological harassment in the legislation. A decision was made to include it to treat it as a labor standards matter. So it makes the approach a bit different. But today we see that there's really a desire on the part of the legislator and the government to really put a bit more focus on it, on the health and safety legislation, and to make both corpus of laws more consistent amongst each other. So the key amendment introduced by the Act, next slide please, was done by the is done like I said, today we're going to discuss amendment to the Act respecting occupational health and safety, the Act respecting labor standard, and the Act respecting industrial accident and occupational disease. The first one we're going to cover is occupational health and safety, and I'm going to let my dear colleague Sarah-Émilie cover that because she's the real expert when it comes to that.
So the first change to the Act respecting occupational health and safety is the introduction of the new definition.
Sorry, Peggy, can you just move it two slides further? Another one, thank you.
So is the introduction of the new definition, the term sexual violence, which means any form of violence targeting sexuality or any other misconduct, including unwanted gesture, practices, comment, behavior or attitude with sexual connotation, whether they occur once or repeatedly, including violence relating to sexual or gender diversity. This is a continuation of the legislative change brought in 2021 by the Act to modernize the occupational health and safety system, which introduced the employer's obligation to prevent and fight the sexual violence. This is an important definition because of this obligation, but also because it is used for the application of the Act respecting industrial accident and occupational disease. We will discuss the relevant provision further in the presentation. Also, the Act respecting labor standard refer to this definition and its section 97.1. It should be mentioned out that the concept of violence was only introduced in Quebec OHS legislation in 2021, which may be considered late compared to the other jurisdictions. As an example, an employer in Ontario has the legislative obligations since 2010 to protect employees against violence and harassment in the workplace. This definition is intentionally broad because we don't want to compromise the main objective of the Act respecting occupational health and safety, which is to protect the health and safety of the worker, hereby preventing sexual violence in the workplace. As you can see, this definition include misconduct related to sexual orientation or that is sexist in nature. And unlike the definition of harassment and the Act respecting labor standard, a single act can be considered sexual violence regardless of its seriousness. For corporation, under the Act respecting labor standard, as I just mentioned, the notion of psychological harassment refer to repeat behavior, verbal comment, act, gesture, and for a single act to be considered as psychological harassment, it must be serious. This introduction broadened the employer's obligation to protect workers' health and safety under the Quebec OHS legislation, and this modification is already into force since March 27. So the next modification, again in the pursuit of the legislative change introduced in 2021 by the Act to modernize the occupational health and safety system, which, as we just mentioned, introduced the employer's obligation to prevent and put a stop to sexual violence. A new regulatory power is being introduced, specifically enable the Commission des normes de l'équité, de la santé et de la sécurité du travail, the CNSST, the Quebec's Workers' Compensation Board, in fact, to provide for any measure to be taken by employer to prevent and put a stop to sexual violence. On the other hand, the Act adds a corollary obligation for employer to implement those measures identified by this regulation. It should be noted that although this provision is presently into force, no regulation have yet been adopted by the CNSST, and that if the CNSST does not adopt one by March 27, 2026, the government will have the power to adopt one in its place. The last set of modification to the Act respecting occupational health and safety is related to the prevention mechanism under the Act. As you probably already know, following the adoption of the Act to modernize the occupational health and safety system, as of October 1st, 2025, all employers with establishment of 20 or more workers will have to develop and implement a prevention program, while employers with establishment of fewer than 20 workers will have to draw up an action plan. As part of their new obligation, employer must identify and analysis for employers with establishment with more than 20 workers, the risk that could affect the health and safety of workers and the establishment, including the psychosocial risk linked to work. These obligations are modified by the present Act to specify that psychosocial risk explicitly include sexual violence. So the employer will have to consider sexual violence during the development and implementation of the prevention program. Finally, the psychological harassment policy required by the Act respecting labor standard will have to be included in the prevention program and the action plan, or the action plan, in fact. Thus, as from October 1st, 2025, the absence of a psychological harassment policy will constitute a derogation under both the Act respecting occupational disease, occupational health and safety, and the Act respecting labor standard. My colleague will be talking about the new provision regarding the psychological harassment policy in a few moments. So let's talk now about the modification of the Act respecting labor standard.
Yes. So if we can maybe just go to the next slide, please. Again. Thank you. And yeah, maybe one more. That's perfect like that. So the modification made to the Act respecting labor standards aims to expanding the employer's obligation when it comes to psychological harassment in the workplace, including sexual harassment. So the main modification, the first one that were made for that, is that a specific obligation to prevent and make stop harassment by third parties toward employees was included in the Act. Then the other change is that the policy title was renamed to reflect that employers are expected to be more proactive. So in the previous version of the Act respecting labor standards, we were referring to psychological harassment and complaint processing policy. Now the Act would refer to policy to prevent and manage situation of psychological harassment, and in the parliamentary debates, it was mentioned that it was done to bring more proactivity and not just focus on the complaint process. So next slide, please. The first one, the obligations from employer to prevent and make harassment stop, even if the harassment was made by a third party. It's more clarification of the case law. We can see that, like, even in 2009, it was something that the former administrative labor tribunal, at the time it was called the Labor Relations Commission, already decide that it was applying. It was including the obligation of the employer to prevent and make harassment stop. So, for example, just to give you a few examples of what that obligation encompasses. In Rodriguez, it was harassment by the client. The employee was a cleaning lady in a hotel, and like she knocked at the client rooms to clean it, and a man who was naked opened the door and offered, like, asked her to have sexual relationship with him and everything. And when she complained to that to her managers, basically they just laughed about the situation and did nothing. So it was said that like the gesture by the client was serious misconduct of sexual harassment, and that the employer had the obligation, when it becomes aware of it, to make it stop, although it was done by a client. In Marquez Vilo, the second case, it was the landlord. It was in a restaurant, and the person was a cook. The employee was a cook, but the landlord of the building where the restaurant was very racist toward the employee. And like he was violent as well with that person. Like he would throw stuff at hers and things like that. And the employer, when they become aware of that, like they did basically nothing to help the employee and make the situation stop. So again, the complaint was upheld. And in Plouffe contre Armoire, etc., it was a supplier that was harassing an employee of the employer. And basically, the employer was a bit more sympathetic and a bit more helpful toward the plaintiff in that cases. Like he kind of tried to intervene, but at the same time, like for him, he was prioritizing to like finish the projects that they were doing with that supplier. So because of that, like he never formally said to the employee, like you have to, the supplier, like you have to stop, like this is not acceptable at all, any message like that. So because of that, the tribunal also upheld the complaint. So now it's very clear in the act that it is covered, but we already have like many examples of situation where complaints were upheld, although the harassment was done by the third parties. Next slide, please. Another big change that is done through the Act respecting labor standards. The Act respecting labor standards, as was mentioning, was already providing since 2019 that the employer must have like prevention and complaint processing policy in place, but there was absolutely no indication in the Act about like what that policy should include. This is something that the legislator addressed in that Bill 42. So it specifically set out the minimal content that an employer must include in its policy. If we can go to the next slide. It must include method and technique used to identify, control, and eliminate the risk of psychological harassment, prevention that are offered to employees. So, and it must include details, for example, like would it be yearly? How would it be addressed with new employees, for example? Would it be done through a third party? Like it must include some level of details. It must also include recommendation on behavior to adopt when participating in work-related social activities. So we know that in many instances, the harassment is not done like during the working hours at the specific like workplace, but it would more be done like in the parties, like Christmas parties or like work lunch, things like that. This is like an environment in which like some people feel more comfortable like to say things that like they wouldn't say like in a formal workplace. That being said, it's very clear in the case law that like the obligation to get an environment free of harassment expand to those settings. So the legislature wants the employer to put specific example on that in their policy. After that, we go in the procedure for making complaints to the employer. The measure to protect the person concerned by a situation of psychological harassment and the person who have cooperated in the processing of complaints. So not only the plaintiff, but also like the witnesses and any other people that could have been involved. Like what is the employer going to do to protect them? If we can go to next slide, please. the process for managing a situation of psychological harassment, including the process that applies to the holding of an investigation by the employer. So, for example, who will conduct the investigation? Would it be done by a third party? Would it be done internally? Like it can say in the policy that it would be addressed like on a case-by-case basis, but like on what factors, for example, and like a bit of timing, things like that are included in that categories. The next point is the names of persons designated to receive complaints or reports. Typically, it would be HRBP or director of HR. If you don't have HR within your organization, it can be someone else from management, but it must be very clear. And we also encourage, it can also be the manager, and we encourage to include like section regarding like what do you do if like it's your manager, for example, harassing you. Make that distinction. And the last point is the measure to ensure the confidentiality of complaints, report, information or document received, and to ensure a preservation period of at least 2 years for the document made or obtained in the course of managing a situation of psychological harassment. That delay of 2 years, it's linked to the fact that the accurate-speaking labor standards provide 2 years for a complainant to make a complaint. So basically, it also say that, let's say that a person makes a complaint internally first, and then they are not happy with the situation, like the result, or the situation like resume at a later date, and they want to do a complaint to the CNCC. Of course, they can do it, but it's good so the employer is going to still have the material from that internal investigation because of that 2 years delay of conservation. All those change, like about the content of the policy, it's going to come into force as of September 27, 2024. So it seems far, but with the summers ahead, it's going to go fast. We strongly encourage you to reach out to us if you need assistance to have your policy reviewed. So you're ready for September 27th and are sure that you have at that date a policy that is fully compliant with those new requirements that are set out in the Act. Next slide, please. Another change that was introduced by the Bill 42 is that the Act now established a specific protection against reprisal for employees who report a situation of harassment against another employee or collaborate in the process of psychological harassment complaint. So there was already a provision that would say, it's a very general provision, basically stating that like an employer cannot retaliate against an employee who exercised a right under the Act. So the fact to complain for yourself is a right under the Act. So it was already established to that, but there was kind of a it was empty, like there was nothing specific for the third parties. For example, if I'm making a complaint because I feel that Sarah-Émilie is getting harassed at work, I have no specific provision. If I'm terminated like shortly after that in connection with regards to that, so it was introduced. So basically, it would be the same way of the same protection than for all other prohibited practice. There would be a presumption if the person can demonstrate that like shortly after the fact that they complained for a call for a third party, for another party, or that they collaborate in the process of psychological harassment complaint, for example, by being a witness into such an investigation, they are terminated, for example, there would be a presumption that it is because of that, and it would be up to the employer to prove that there are another just and sufficient cause that have nothing to do with either the employee making that complaint or their participation into the investigation. And if it is just like, if it has just been slightly influenced by that, it would be enough for the complaint to be upheld. Like it must have really nothing to do pursuant to the contamination theory. This is already in force as of March 27, 2024. So just be aware of that. Next slide, please. So another big change is provision of amnesty clauses. Amnesty clauses, as many of you probably know, are mandating employers to ignore past T is missing, past disciplinary measure imposed on an employee for misconduct involved for past misconduct. So you cannot rely on things that happened a year ago, for example, even if it's very similar to the actual misconduct that you're considering at the moment. When imposing disciplinary, so it in case of misconduct involving violence, employer will no longer can or be able to consider not consider those past misconduct. They would have an obligation to consider them, although an amnesty clauses exist. Next slide, please. So just a few more details on that. This is obviously especially relevant in unionized workplace because it's mostly in collective agreement that we would find amnesty clauses. It's like a lot less common in non-unionized workplace, although I've ever seen similar provision in employees handbook, for example. Obviously, the purpose of the amendment is to better protect individuals from repeated offenders or people who are physically or psychologically violent, like on a regular basis, but like with some time between each instances. Currently, as I was mentioning, like these clauses limit the employer ability to take into account the past disciplinary measure they imposed for violent conduct if it was not close enough, if it was like watched by the amnesty clauses. It's sure that in practice, employer like would not be like shall not consider an incident that happened 20 years ago the same way that an incident that happened like 1 month before the duration of the amnesty clauses. Like obviously, if the person like if there are a long time between the two instances, it would be kind of considered as an extenuating circumstance, but they will still have to consider it. And this is already into force as of March 27, 2024. So next slide, and I think that this is the last, I'm not sure, but yeah, this is the last one for me regarding the Act respecting labor standards. So basically, there was a provision that was created in the Act respecting labor standard, allowing the tribunal to order an employer to pay punitive damage to an employee who is a victim of psychological harassment, even though it is also recognized that employee is also recognized as a victim of employment injury resulting from that same conduct constituting harassment. It was not possible until now because the workers' compensation system is a no-fault system, so it was kind of contrary to giving punitive damage. But the legislator made an exception to that, and now, although the person is receiving replacement income by the CNSST because they, as a result of their employment injury, they would also be able to be to receive punitive damage if obviously the situation meet the required criteria for that type of award. So, and this is already into force since March 27, 2024. So up to you, Sarah. So
now we will discuss the modification to the Act respecting industrial accident and occupational disease. The Act creates 2 new presumptions of employment injury, which are intended to facilitate the recognition of an employment injury resulting from sexual violence in the workplace. Following the entry into force of these 2 presumptions, which will happen next September 27, in order for his or her injury to be recognized as an employment injury, a worker who is a victim of a sexual violence event will only have to demonstrate the condition of application of one of these presumptions. It will be then up to the employer to review that presumption. So the creation of those presumptions will increase the employer burden of proof. So let's look at those presumptions. The next slide, please. The first presumption will apply to what I like to call internal event only. So it will apply presently when the sexual violence is from the employer or one of his officer or employees. If we look at the future section 28.0.1, the condition of application will be the demonstration by the worker of an injury or an illness. An injury is something that happened like a traumatized, just quickly after an event, and an illness, it's something that will occur on a certain period of time. So that injury or illness is the first condition, and two, that this is resulting from a sexual violence committed by his or her employer or its officer or one of his employees. Note that there is no specific time limit for the application of this presumption, but the worker will have to respect the time limit provided by the law for the filing of an employment injuries claim to the CNSST. We will talk about the time limit, later in the presentation. The second presumption will apply to any sexual violence event, but only in case of an illness. So if we look at the future section 28.0.2, the worker will have to demonstrate the presence of an illness, firstly, and secondly, that this illness appear within 3 months of an event of a sexual violence in the workplace. As we can see, the sexual violence does not have to be caused by the employer of one of his workers, but this section 28.0.2 state that the sexual violence must occur at the workplace. The term workplace is not defined by the Act respecting industrial accident or occupational disease, but is defined in the Act respecting occupational health and safety. So it's let's look at the definition we can find in this Act. Workplace and the Act respecting occupational health and safety mean any place in or at which a person is required to be present out of or in the course of work. What we are looking for is the connection to work. You have to know that the case law interprets that term very broadly, so it's therefore essential to establish, as required by the Act respecting labor standard, rules governing social activities organized by employers such as office party or cocktail, because it's more likely that they will be considered work-related in the analysis of a claim or the application of this presumption. The next set of modification is related to new measure to protect the confidentiality of the medical record held by the CNSST. Next slide, yes. So we have changed in the access procedure, and we have 2 new sanctions that are created. This is very, very, very important to know that those changes are applied to all employment injury, not only for the employment injury related to sexual violence. So the first change I want to talk about is the change to the section 38. Next slide, please. So if we look at and those changes will be coming into force in next September 27. So if we look at the present section 38, an employer has a right of access free of charge to the record and the possession of the we'll say CNSST in respect to an employment injury suffered by a worker while he was employed by it. However, only the health professional designated by the employer has a right of access free of charge to the medical record or physical rehabilitation record in the possession of the CNSST. So, the new provision will say in the last part that, however, employer does not have a right of access to the medical record and physical rehabilitation record in the possession of the CNSST in respect to the employment injury suffered by the worker. Only the health professional designated by the employer has a right of access free of charge. I will comment that this modification in a moment. Next slide, please. Section 39 is also amended. So the actual Section 39 say an health professional shall report to an employer who designated him in respect to the medical and physical rehabilitation record of a worker to which the CNSST gives him access. He may, on that occasion, give the employer a summary of the record and an opinion to enable him to exercise his right under this act. The modification is related, will say, in fact, he may, on that occasion, communicate to the employer only information required to give the employer a summary of the record and an opinion to enable him to exercise his right under the Act. At first sight, those change to Section 39 and to the 38 don't seem to be very important, but they are. Theoretically, it's true that the access to medical records already had to go through a designated health professional, but in practice, it was a very different story. The health professional designated by the employer was only a kind of a mailbox. So upon reception, they only transfer the entire file to the employer without any summary and anything. So considering this practice, it's clear now the access to the medical file will be more restricted. Not only does the health professional designated will have to summarize the file as required by the law, but the law now also will also specify that he or she will only be authorized to communicate the employer the information required to enable him to exercise his right, which I think can lead to some issue. Firstly, as we all know, health professionals are not cheap, so it will surely increase the cost of an employment injury if for every file, a physician will need to, physician or any other health professional will need to summarize and analyze the file. Secondly, the determination of what is required or not to enable an employer to exercise his right will be up to the health professional. But it's more a legal question than a medical question, which is normally outside the health professional expertise. The Act also creates to ensure the compliance with the provision governing the confidentiality of the medical record. Next slide, please. Two new statutory offense. Employers attempt to obtain medical record and illegal disclosure of information by an health professional will be an offense under the Act respecting industrial accident and occupational disease, punishable by a fine from $1,000 to $5,000 for an individual and $2,000 to $10,000 for a corporation. So it's clear that physician, health professional will not be willing to just transfer the entire file to the employer. Then it will be more difficult for the employer to obtain information containing in the worker's medical file. However, I think there are two possibilities for employers to obtain this information. regardless those new modification. The employers can have the worker sign an authorization of access and request directly the document and the information to the clinic or the hospital or the physician, or you can challenge the employment injuries claim or any other decision rendered by the CNSST. In that case, the CNSST will give the employer access to the relevant information needed to defend themselves. The next modification, so next slide, please. The next modification is regarding the time limit. So the time limit for filing a claim for an employment injury resulting from sexual violence will be extended from 6 months to 2 years. There are two reasons behind this modification. First, the statistics show that a large number of claims refused in case of sexual violence are due to the failure to comply with the 6-month time limit. And there's a confusion in the time limit. The time limit for the filing of a complaint under the Act respecting labor standard for psychological harassment is 2 years since 2019. So following a single event, a worker may have 2 years to file a complaint for psychological harassment, but only 6 months to file a claim for employment injury. Then by extending the time limit for filing a claim to 2 years, the Quebec's workers' compensation legislation will be aligned with the time limit and the Act respecting labor standard for the filing of a complaint for psychological harassment. And B, the impact of the extension of this time limit will be that it will be more difficult for employer to gather evidence, need to reboot the new presumptions, or to simply defend themselves against a claim, because time may erase the memory of witness, or evidence might get lost. Therefore, we recommend that the employer do not wait until they receive a claim to collect the statements from the key witness and document, and to do so as soon as they become aware of such event. The last modification in the Act respecting industrial accident and occupational. Next slide, please. So the last modification I want to present to you is a new exception to the imputation rule. In Quebec, the general principle of imputation is that the CNSST charged to the employers the cost of an employment injury sustained by one of his workers. Depending on its cost, this employment injury might increase the annual contribution of an employer to the Quebec's workers' compensation plan. In brief, the Quebec's workers' compensation plan is kind of manage and finance like an insurance company. So if you have a lot of claims, your contribution will be higher. But as you may have noticed, the change made by the Act to the Act respecting industrial accident and occupational disease will have the effect to facilitate the recognition of employment injury resulting from sexual violence. In order to limit the involvement of employers in those kind of claims, the cost of those files will be charged to all employers, not only to the workers' employers. But it should be noted that the cost charged to all employers do not disappear. So the result will be that the contribution of all employers will be increased. So it's still important to manage and look at the file that are the file that are filed to the CNSS. That's it for the notification regarding the Act respecting industrial accident and occupational disease.
Next slide, please. Next slide, please. Thank you. So then we have 10 more minutes. I want to keep maybe 5 minutes for the questions. So very quickly, key considerations for employer, the overview of the risk and obligations. I think the obligations, we won't go through that again. Like this was the main, pretty much the main topic of our presentation. In terms of risk, obviously, if you don't comply with those obligations, you expose your company to complaints by employees. Employee can make complaints that their workplace is not free of harassment, or that the employer did not take the proper means to have harassment prevented or stopped if it happened. You can also be fined both under the Act respecting labor standards and the Act regarding occupational health and safety. The amounts of the fine would depend of like the seriousness of the misconduct. Recommendation for compliance, I think at that point, what must be said is that it's very important to review your policy, but also your practice, your procedure, how do you act in practice. And also another big important point is to ensure that like both your employees, but also your group of managers get the proper trainings regarding those new obligations to be able to implement them properly. You have until like we said, like some of the obligations are already enforced, but it's never too late. And for many of them, you have until the end of September to comply. So we would recommend that like you get ahead of that. Consequence of non-compliance, like I mentioned, like this could be fine, this could be like complaint being upheld, like having to pay damage to employees. I think Sarah wanted to touch briefly as well regarding like when you get fined, when you are guilty of it.
Yeah. Under the OHS legislation, the consequence may be a little bit more important because some other law will link some example license to the compliance to the Act respecting occupational health and safety. So, as an example, if you have too many statements of offense under the Act respecting occupational health and safety, the Régie du bâtiment might suspend your license for a couple of days or even weeks or months. So it's important to take it very seriously.
So if we go to the conclusion, next slide, please, before addressing some of the questions that were asked in the chat during the presentation. As you were able to see during that presentation, Bill 42 introduced significant legislative change to many important statutes that govern the relationship between employers and employees. Those amendments are meant to ensure a couple of things: better management of harassment and violence situation in the workplace, to further harmonize existing legislation between the Act respecting labor and standards and the occupational health and safety corpus, and to facilitate as well recourses for the victim, for example, the presumption that were created, giving more time to a victim of employment injury to make a complaint, like from 6 months to 2 years, all of that, like it's done to make the victim's life a bit easier through that. And I cannot, like, I think we said that a couple of times already, but I think it's very important to emphasize that employers need to review their existing practice and policy to ensure compliance with these new requirements. We're happy to assist any employers with that. So, Stephanie, I think we had a couple of questions.
Yes, I have a first question for you, Arianne. If you could say more about making stop harassment by third parties and to expand on the obligation this places on employers.
Mhm. So obviously, like the tribunal in the past case law regarding harassment by third party recognize that like it's not as easy as if the harassment is done with another employee, because obviously like you don't control, like there's no subordination link, for example, with clients or with suppliers or with your landlord, for example, to be back on one of the example that I gave. That being said, the tribunal says that the employer must take an active role when it becomes aware of a situation of harassment by a third party, and it's not enough like just to make like, I would say, shy contact saying like, hey, we heard that you did that, but be like, no, the employer has to be really more strict about that. We can see from one of the decisions, for example, that like the employer should have changed supplier for project that were ongoing. So like it was said that because the employer did not do that, it was one of the main reasons why the complaint was upheld. So as you can see, like this is pretty heavy as obligation. Just to give you another example in another decision that I did not discuss today, it was in a town council, and like it was a citizen that would go to like every meeting of the town, the town hall at the town council, and he would harass like people that were there, like of the town employees, and basically the employer took an injunction to prevent that citizen to be able to attend those town meetings. We're not sure if it like, and it was granted, like the Superior Court granted that exception. The interesting question is like, is it something that you have to do every time? Like if the other things doesn't work, and like basically, especially a public place like that, like I think in a private setting, private office, for example, I think that it may include an obligation from the employer to restrict that harasser party the right to enter into the premises. Obviously, in public setting, it's more difficult, but we can see that like it's certainly a possibility that the court consider that yes, you can even go seek an injunction and get it, and maybe in some situation you have even the obligation to do that. So this is quite interesting. This is a new development. Like we're not seeing that a few years ago. It's something pretty recent, but it's something that in some of the more serious situations shall be considered, certainly.
I have another one for you. If it's about the policy, if you have to provide the name of the person in the policy, or if you can just say manager, human resources, or outline.
It's okay just to have categories of people. You don't specifically need to put the name of someone, although it would be a good practice, but obviously it's required to update your policy if there's a change in the name of the people. But I think that it must be like, you must provide, for example, you should have like a dedicated email address for that, like having something that like it would be easy for the employee like to reach out without having to do like a lot of research about like how to contact and who are actually those people. So clarity is the key, but I don't think that it means that you have to give a specific.
Good. And I have one last one about amnesty clauses is how long does this protection period last?
Oh, so it depends of what is set out in the collective agreement. Like amnesty clause are not something that legally exists. Like it's not something that stems out from the Accurate Speaking Labor Standards or any other statute. It's something that the parties to a collective agreement would include in their collective agreement. It would say, for example, if the employee does not engage in a similar misconduct within like 6 months or 12 months, for example, of being disciplined, that past discipline would be considered erased, like washed out from their disciplinary record. So it's really what the parties decide. I would say that typically it's between 6 months and 2 years, what I've seen, but it's really what the parties would decide.
And that's it for the questions.
We have a new.
time you said that there's another one.
Yeah.
What if the third party is a patient in a healthcare context? Does the same apply?
That's a very interesting question. Obviously, I think that like you would have to consider that in a situation like that, the patient probably also have rights, but the patient also abide like by code of conduct. Like there are rules applying like to patients like receiving like healthcare service, and if they do not comply with that, I think that you'll have to kind of balance the rights and the obligation of each party. For sure, it add a level of complication, but I think that yes, at some point, like it should, like administrative measures can be taken against patient at some point, obviously subject to their rights to receive like the proper care. So that's one that would have to be considered with on a case by case basis. And I think there was something about 2026.
Yeah, I saw a question about 2026. So the 2026, March 2026 deadline is for the CNSST to adopt the regulation regarding the specific measure the employer has to take to protect and the employers and to put a stop to sexual violence. The provision regarding this provision regarding is presently into force, but we don't have any
regulations.
Any regulation. But if the CNSST present one tomorrow, it's not like it may say, but you have to comply with it in a month, or normally they will give you a delay. The other provisions regarding the prevention mechanisms are coming into force on October 1st, 2025, because this is the date when the modification introduced by the Act modernize the safety plan will coming into force.
Yeah. So it's already 101. I want to be respectful of everyone's time. Thank you for having been with us today. As I said, we're looking forward to hear from many of you regarding the review of your policy. We'll be available through the summer to assist with that. And in the meantime, if you have any question on today's presentation, feel free to connect with either Sarah-Émilie or I or any member of our teams, really. So thank you very much and have a good afternoon. Thank you.